Other questions on this? Okay, next I'm going to talk about the next couple of slides that are talking about vested rights and this standard practice, it seems, that these Invenergy companies, not just these energy companies, not just Invenergy, but some of the others as well, that have this legal threat that they apply all the time. It seems to be a common tactic that as soon as the supervisors or anybody in the county says, wait a minute, our ordinance is 20 years old and it runs to a half a page. We need to update that. As soon as these energy companies, not all of them, but some of them, as soon as they hear that, they're sending letters to the supervisors, as they did in Worth County, and say, no, we've been thinking about this project for a while. We've been buying up land rights for a while. We've got vested rights. We're going to take you to court. And then the rumors start that the energy company is going to sue the county, and the county is going to have to pay back all these millions of dollars that the energy company spent in buying these land rights. And frankly, it's all just crap. Now, vested rights is a legal doctrine. It is a real thing, and it's related to zoning issues. It's legally, it's used to protect people that have a permit from changes to the rules after that permit has been issued. So, as an example, if I get a building permit that says, I'm going to put up this building on my lot, and it's going to have these particular setbacks, and it's going to be this tall, and I submit that application, and it's in accordance with the rules, and I get a permit, and the next week, those rules change, that would now negatively impact my building. Maybe the setbacks changed, or the height restrictions changed. Well, this vested rights legal doctrine says, no, Jeff was issued this permit under these rules. Even though the rules have changed, he's got a vested right to continue that project. Now, there's a lot of what ifs involved in there. And the reality is that if it goes to court, the court goes through a fact-finding trial. And they consider a variety of tests before they say, yes, you have vested rights, or no, you don't. And we'll talk about some of those in a moment. So in this case, when the energy company claims vested rights, it's not automatically granted. They're not suing the county. They're merely petitioning the court to grant them an exemption from certain rules that they say should not be applied to their project. And for most counties, if that happens, the insurance that the counties carry pick up the tab to hire the attorneys to represent the county in that court case. Now, there's another way that vested rights are addressed, and that's typically built into our zoning ordinances today. It's probably in your zoning ordinance. It's called non-conforming activities clauses. The non-conforming activities clauses means if you have something in place, and it's okay today, but tomorrow the rules change, and so now it's no longer okay, they don't make you tear it down. You can continue that in operation until the cows come home. You just can't change it unless you change it in conformance with the new rules. So you're grandfathered in. And in a nutshell, that's kind of the whole concept between vested rights, is that grandfathering in. And I also want to make note that the courts are not going to fine the counties for implementing these ordinances. That doesn't happen. In fact, you'll see here in some of the Iowa Supreme Court rulings, the first two, I'm going to show you how the Iowa State Supreme Court believes and expects that these rules are going to change. Zoning ordinances are expected to change. The Iowa State Supreme Court has said zoning is dynamic and changing, with any existing restrictions being always subject to reasonable revisions in light of changing community conditions and needs as they appear. Does anybody doubt that the size and the technology of wind turbines have changed in the last 20 years? Does anybody doubt that our state of knowledge and science around impacts from wind turbines have changed in the last 20 years? So it stands to reason our ordinances should change to keep pace as well. Supreme Court has also said property owners in the area affected by a zoning ordinance, as well as adjacent landowners, and I would say persons with wind easement rights, have no vested right to the continuation of the current zoning. Harken back to comment number 1. They expect changes. Now, on the next two, with regard to the ordinances themselves, the language of the ordinances, the Iowa State Supreme Court has said a zoning ordinance, including any amendments to it, carries a strong presumption of validity. And that's because the courts have said the challenger must show, if they're going to challenge the ordinance and say the ordinance should not apply, or the ordinance is bogus, or the ordinance is onerous, or whatever the case may be, the Supreme Court has said the challenger must show that the ordinance is unreasonable, arbitrary, capricious, or discriminatory, with no reasonable relationship to the promotion of public health, safety, or welfare. Next, what the Supreme Court has said about moratoriums. Some people claim that moratorium is you can't do that. The county supervisors just can't say, nope, we're going to take a pause on that stuff. We're not going to approve any permits for some period of time. Supreme Court has said the moratorium aids a governing body in performing the legislative task of municipal planning. They aid in bridging the gap between planning and its implementation into legal measures. So looking at the problem, looking at what kind of solutions we need, and implementing that solution takes time. And a moratorium is a perfectly valid tool that governments have to use for that period. They say they may be used to preserve the status quo while study of the area and its needs completed, thus serving a significant public purpose. They've also said, with regard to moratoriums and changing of rules, that with regard to work on completion of a project that has been previously permitted, vested rights to continue development would not necessarily be true. So in my example, I've got a permit. I applied for a permit yesterday to build this house or build this building. I got my permit, and next week they changed the rules. And I knew that they were working on those rules. I have attended those public meetings for the last 3 months because this stuff takes time. Supreme Court has said if the permittee had actual or constructive knowledge of the pendency of the zoning amendment at the time of the issuance of the permit and of the expenditures and work done under the authority of the permit, I still might not have vested rights. So it's not a given. Just because I say I've got vested rights doesn't mean that I do. Once again, the court will decide. They'll look at a variety of things to determine that. My point in going through these things, these Supreme Court statements and the conversation about vested rights, is because Joe Public out here and about in rural North Iowa, we hear these things and we hear the energy company's going to sue our county. They're claiming vested rights. It's, oh crap, I guess we better give up. No, you have rights as well. We have rights. Now, vested rights are a real thing. And if they've got permits, if they've gone through that permitting process, I agree handily. If you've got a permit issued under old rules, the new rules may not apply to you. But if you've not got a permit yet, the question remains, do you have